So, good afternoon, everybody. For those who don't know me, I'm Tommaso Virgili. I'm a postdoctoral research fellow at the Migration, Integration, Transnationalization Department of the WCB. And I welcome you to our fourth session of the series of events on Islam and liberalism in contemporary society. Today we are going to address a burning issue, namely Islamic law and its presence in a Western legal system. And first of all, we need to ask ourselves, what is Islamic law? We have all become very much used to the term Sharia, but Sharia has many meanings, and sometimes it is profoundly misunderstood. It may refer to the abstract will of God. It may refer to the spiritual path towards God. It may refer to the jurisprudence devised in centuries by the legal scholars of Islam, the fiqh, as well as to the modern interpretation given of Sharia in parliaments and tribunals of modern Muslim states. However, it may also refer to an abstract, oftentimes stereotypical understanding of Islamic law as allegedly binding every Muslim on earth, even in the West. In turn, the different interpretations that can be given to Sharia are certainly influenced by Islamic currents, Islamic individualities. As we love to say in this series, there is not one Islam, there is not one prototypical Muslim, and Islam being a religion without a church is open to many different interpretations. And this also allows me to already introduce you to the next event of this series, which will be dedicated to the exegesis of Islamic scriptures. It will be on the 6th of June at 5:30. The main speaker will be Professor Muannad Khorshide, theologian of the University of Münster, who will indeed highlight that there are many different ways of approaching Islamic scriptures. But without further ado, let me introduce you to Professor Elham Manea. I'm very glad to have her as our guest here. We have been knowing each other for many years, and I've always admired Elham, both for her scholarly rigor, but also for her earnest commitment towards human rights. So Elham is a Swiss Yemeni Egyptian professor of political science at Zurich University. She specialized on the Arab Middle East, but she's also a writer and a human rights advocate, as I was saying. Her research focuses mainly on regional politics of the Arabian Peninsula, fragile state in conflict zone in the MENA region, and especially Yemen, as well as women under Muslim laws and political Islam. So Elham's lecture today will address the question as to whether Islamic law should be introduced into Western legal system, and she's going to address the topic both from a theoretical and an empirical perspective, because Elham conducted extensive fieldwork in the UK, in the Sharia Council. You might already know that there are some entities in the UK that are legally recognized as providing judgments to Muslims on family issues when requested. This pioneering endeavor actually went into a book, to Elham's book, Women and Sharia Law, The Impact of Legal Pluralism in the UK. So Elham will have up to 45 minutes for a lecture that, as usual, will be followed by a discussion with me and with the audience. This time, the structure is a bit different, the format is a bit different because this is an hybrid event, so we have people following remotely. I would like to remind those who follow remotely to keep their microphone and their videos off, and everybody, both in the audience and from the Zoom connection, will have the chance to ask questions. For those who ask questions on Zoom, please write them in the chat. I would like to remind everybody that this is a recorded event. It will be uploaded on YouTube and on the WCB website. For privacy reasons, only us on the podium will be part of the video. And for the same reason, I'm not going to mention the name of people commenting or asking questions in the chat, unless you explicitly request me to do so. So, I think now, Elham, it's your turn to start. Thank you very much.
Thank you very much, Tommaso. I really appreciate this introduction, and I appreciate the invitation to this series. The subject is controversial, and I understand that. And I thought that perhaps a good way to start is basically to define what we're talking about. And then I will bring the personal research background that led me to embark with this research in the UK. I also followed up afterwards in South Africa. And I will talk then about the British context and the soft legal pluralism applied there with final remarks. Let me first start. It's like when we talk about legal pluralism, we are in fact talking about a situation where different groups are subjected to different laws within the same society, within the state setting. And as you see here, the first definition, you can read it for yourself, started in 1972. And when it concerns the subject, it is very much a contested subject matter. So you have two theoretical approaches in general. One that advocates legal centralism. And it basically tells you the state has to be the foundation in which liberal democratic nation rely on, argues for state's monopoly on legal production, and at the same time warns of depriving the state of this capacity while highlighting the consequences of legal pluralism on weak groups within the minorities, such as women and children. The other theoretical approach argues for legal pluralism, maintains that legal centralism is more relevant within a Western modern jurisprudence, that it ignores the experience of non-Western countries, and it cites a more complex relation between law and society. It does insist that legal pluralism is the adequate system that guarantees the protection of minorities' rights and their entitlement to be different. And it is shaped by forms of cultural relativism. I will also say it is very much part of a certain strand of postmodern paradigm. Comes this personal research background. This is a book that was actually my habilitation, published in a book with this title, The Arab State and Women's Rights, The Trap of Authoritarian Governance. I conducted fieldwork specifically in three countries, Yemen, Syria, and Kuwait. Observed the legal situation in different MENA region countries. And my question was basically this research question. The post-colonial and newly emerging Arab states, which often did not hesitate to grant women their suffrage rights, voting rights, were very much reluctant to grant women rights that concerned their private lives. The family laws remained religious to the core. And my question was, why? And once I posed that question, the political dimension of these family laws became clear. Now imagine, finished my field work, 2008, started to write my book, my habilitation as well. And then a discussion started in Switzerland where some advocating legal pluralism started also to argue perhaps we should also have a form of legal pluralism allowing Muslim minorities to use their Islamic law in family matters. okay, in family issues. Looking at legal pluralism in practice, through my research, I realized that legal pluralism in the MENA region, as I said, family laws are derived from religious provisions. And with that, I mean all religious groups. Each has its own religious family law. Religious family law, not only Muslims. At the same time, you realize that this is the legacy of the Ottoman millet system, a system that was introduced in order to be able to control certain areas with majority of non-Muslims, at the beginning specifically of the Ottoman Empire. And with that system, you allowed different religious groups to have their own, how should I say, boundaries. You have a religious leader, and this religious leader is like more the connection between the community and the state. And family laws were part of the issues that were regulated according to the religious groups' canons. The outcome, however, if you look in the Middle East, in the MENA region, notice the person that I quoted, Albert Hourani. Albert Hourani, he wrote this in 1947 when he wrote, in fact, about this type of system, and he said that the outcome of this how should I say, form of legal pluralism was none other than close communities. The first time that that expression was used, close communities with parallel society, was in fact within the Middle Eastern research studies. He called it, each community was a word sufficient to its members, exacting their ultimate loyalty. The word touched but did not mingle with each other, and each looked at the rest with suspicion and even hatred. Okay? If you look, at least from my own study background, for that habilitation, what one could argue is that when it concerns to the consequences of legal pluralism in practice, one realizes that this religious nature of family laws has further fragmented society, divided society. You don't have civil marriage in the MENA region, with the exception of one country, and that is Tunisia. But Tunisia was always an exception in certain respect. It has kept the society divided, hindering intermarriage between Sunnis and Shia, Christian, Muslims and Jews, superior tribes and inferior tribes, etc. And it has sabotaged the development of a national identity. And there is a dimension, but it's not our subject for today, and it has to do with the social base of power for the political elite, and that was, in fact, the subject of my book. The consequence, however, in general, within this research that I just presented, countries applying legal pluralism often feature stratified citizenry. Here you see a hierarchy, and with those who have the political power as a group, often standing at the top of the hierarchy. Family laws are very much political when it concerns this dimension, and double discrimination syndrome, and this double discrimination syndrome is the gender dimension that I often also insist on. Women are sandwiched between their own needs for equality and justice as women and as citizens, and the needs of their ethnic religious communities, which often feel that their very existence is threatened within the state and hence demand ultimate loyalty from their members. So you can imagine, once that discussion started in Switzerland, I took a clear position, arguing against introduction of Islamic law. I will explain later why. But at the same time, those who were arguing for legal pluralism use Britain as an example. And I'm a scholar. I thought maybe the Middle East has certain contexts and features that may be different. Let me examine Britain and see. Maybe it would be a different experience. We have Tunisia, for instance, as an exception. So what I did was basically, I went there, and the outcome was Women and Sharia Law, the impact of legal pluralism in the UK. If you want it in German, luckily it was translated in 2022. And the translation included also a chapter about the situation in German-speaking countries. Let's just talk about British context. I went there, okay? And it was really a very rich experience. If we focus on the British Muslim context, it's very diverse, and that's exactly connect to what you said in your introductory remarks. We're talking a very, how should I say, heterogeneous group. Numbers estimated right now at 6.3%, I'm sorry. That was the latest Pew Research Center statistic of 2016. Although the Muslim population is divided into 14 nationalities, the most important thing is that the 2/3 of them, they are of South Asian context. So Indian, Bangladesh, and Pakistan, these are the countries which are more represented within a British Muslim context. At the same time, if you look at the context of Britain, I mean, you have different features of the political context. I can talk about it later. Also, how the British Muslim communities were constructed, because before they were called the Asian, South Asian. Over time, they became the Muslim. And with that construction, one avoided looking at the diversity within these communities. But the most important thing is that if we look at the type of policies that were implemented specifically of the 70s onward, you see a form of multiculturalism based on group identity. And that stands against diversity as a lived experience, where we live with each other, with our diverse background, religious identities. Rather, it was turned into multiculturalism as a political process. And that is actually an expression that I borrowed from a colleague that I really respect, Kenan Malik, who basically said these are policies that try to institutionalize diversity and puts people into ethnic and cultural boxes, defines individual needs and rights by virtue of the boxes people are in, and uses those boxes to shape policies. We end up, instead of living in a multicultural society, we end up with what Amartya Sen, the Nobel laureate, the Indian Nobel laureate, what he called monoculturalism. The twain never meet. We live in these close communities parallel to each other. And unfortunately, when we look at the outcome, multiculturalism based on group identities, the one that was applied in Britain, we end up with segregation. And this is an issue that has been looked at lately more and more. And there was the report, it will come later. Yeah, but what's it? Okay, the Casey report, sorry. There was also the Casey report, which addressed the issue, and then came the one that you mentioned, where they were in that report specifically addressing segregation. the report said minority groups have become both more dispersed and in some cases more concentrated and segregated. That means you have those who basically leave their close communities, go up the social ladder, but you have those who are more or less remain within. And people of Pakistani and Bangladesh ethnicity tend to live in more residentially segregated communities compared to other ethnic minority groups. And segregation, unfortunately, is compounded by the pattern of transnational marriage taking place. That means it's more and more you see that marriage, you have spouses brought from the villages or the origin place, and how should I say, integration start over again and again and again. Comes right now the soft legal pluralism. There are two, soft or weak legal pluralism, because it depends on how you look at it. And if you ask some British politicians, they will tell you we don't have legal pluralism, weak or soft or strong. I beg to differ. You have two types of, how should I say, structure, parallel legal structures where Islamic law is applied. The first one, these are Sharia councils. They are basically living, I mean, they exist, they have their great centers, and the number of councils is unknown. You have those who would say it's between 35, and you have those who would say, no, it's 85, and you have those who are saying actually more and more, specifically with the COVID. What interests me is that you have, in fact, 5 very important Sharia councils well known in the UK. And focus is on family disputes, not subject to any legal supervision, deny access to legal advice and legal assistance, and appellation is excluded. The second part, which I consider, to be honest, more problematic, is the Muslim arbitration tribunals, and it's based and working legally, based on the British Arbitration Act of 1996. That Arbitration Act was meant for financial arbitration. It was used afterwards by Muslim, but also Jewish communities. Judgments legally binding, as long as the spouses agree to the arbitration, and you definitely have parallel legal structure. For instance, you have family disputes, violence in marriage, child sexual abuse, etc. These seem to be cases that are dealt within these tribunals. The question is basically, who turns to Sharia councils? You have a certain problem. Why do the women go there? And here you see majority are women, and women are going there either because they seek in religious divorce, they believe civil divorce is not enough. It is enough even from a religious perspective, Islamic religious perspective. Women who were married outside the UK, here marriage is recognized in the UK under international private law, legally possible to dissolve it through common law. Very often women who turn to Sharia councils are not aware of this fact. And the majority, in fact, are women marrying in the UK, but not under civil law. And that is something you have to pay attention to, because it's not only something that is affecting Britain. You know, you see specifically after 2015 a certain issue regarding marriages that are conducted religiously, but not registered in a civil registration. Here, they have a religious marriage, fail to register it, and such marriages called nikah. You have to understand, when I went to the UK, I was so always surprised when they would tell me, because I was very much in contact with many women, British of South Asian background, they would say this is nikah, about the marriage. But in Arabic, nikah is intercourse, for God's sake. It's like, so, all the time I was like, okay, why are you using this word? But anyway, it seems to be the word that is being used for marriage. But these religious marriages are not recognized under civil law, so these women must go to a Sharia court to get a divorce. Now, majority of women, as I said, turn to Sharia counsel to get a religious divorce. That's what they want. They want a religious divorce. And there's a survey of 2017, which I basically, for a TV documentary of Channel 4, I was a scientific consultant for this survey, but also, most important, for this documentary. 60%, according to this survey, 60% of Muslim marriages are not registered. 78% of women surveyed said they want their marriage to be registered. Now, you may ask yourself, why are they not registering their marriages? Because if you don't register your marriage, you will not have the protection afforded by the common law for women divorcing. You see several reasons. You have lack of knowledge about the legal status. Many thought that they were actually protected by the common law. A husband makes a deliberate attempt to trick his wife out of registering a civil marriage. And husband is entering into a polygamous marriage. I also met some young women who would like to experience and test a relationship, have sex, and they have it by using this before they decide to have what they consider real marriage, real civil marriage. And then you have, unfortunately, also a very important factor, and that is the mainstreaming of a new fundamentalist interpretation of Islam, which is propagating the false assumption within closed UK communities that a Muslim woman is only divorced through an Islamic divorce, which in fact contradicts the established practice in Muslim-majority countries. Did I talk? Good. Important, and I have to emphasize this, women are not seeking mediation. What they want is a religious divorce, like a get in the religious tradition. What they need is a procedural measure that allows them to get a religious divorce without having to go to a religious court. Now, let me go back to a very important question. At the beginning, I said I wanted to see maybe the experience in the UK would have been different than the one that I've seen in the MENA region, in the Middle East and North Africa. And that's why the question for me, what type of Islamic law is being used as a framework and implemented within Britain's Sharia councils or courts, sorry. And unfortunately, it's the classical Islamic law with all its contradiction and discrimination. I'm glad that you will have another lecture by my colleague who will talk about Islamic law. the manner by which I define Islamic law, because as you said before, yes, you have different ways of defining Islamic law. But when we look from a gender perspective, I prefer to define it by the way it's being implemented as a jurisprudence in Islamic State and within Muslim family laws. I mean, with that, it will become clear what we're talking about. It's not about the possibility of justice, possibility of reform of Islamic law. That could happen in 100 years. But it's how it's being implemented. Because once you look at it as how it's being implemented, it becomes clear that it infringes and violates human rights with impunity. With impunity. You have general features. Traditional Islamic law is based on gender inequality. With all due respect, there is no way of saying that differently, but it has to do with this. Notice here, it's a selection from the corpus of legal opinions of jurists developed over the course of Islamic history, especially between the 7th and the 10th centuries. The 7th and 10th centuries. So imagine how that historical period looked like. How it looked like at that period. What was the gender or what was the role of women during that period? What was the legal status of women during that period? During that period, slavery was an established institution. So once we look at it at this way, it becomes clear what we're talking about. It becomes clear. So traditional Islamic law is based on gender inequality. As a rule, personal status laws in North Africa are more progressive than in Arab East. That means the more that you move away from the Arabian Peninsula, the better the family laws would become. And I will make a comparison. But if you exclude Tunisia and to a lesser extent Morocco, you have certain characteristics that seems to be common to family laws in all Arab states. Notion that men are women's keeper, have a degree of command over their lives. Male guardianship is what we're talking about. The guardianship is, if we basically translate that into laws, obliging husbands to support their wife financially, and at the same time, in return, ordaining their wives to obey them. It's connected, both. And you have to understand that marriage is seen by the jurists during that historical period as a contract where a female provides certain services, specifically allows the man to have sex with her, and in return you have these financial support. Think about the historical period. You know, it's interesting that we still apply these laws. The question is like, why we are applying these laws today? Why didn't we change them? And grant men alone the right to unilaterally divorce their wives and the right to require their return in the event of a revocable divorce, and restricting women's ability to marry, move, work, or travel freely without the consent of their male relatives or husbands. Male guardianship, again. Now I thought I will make a comparison between one of the best family laws, Tunisia, Code of Personal Status, 1957, during that time in Switzerland, right now my country as well. This was a better family law than what we had at that time. And the Yemeni family law that is still applicable until today, okay? And if you look here, you see two words. Tunisia is an exception. We all say that. Feminists say that. Women rights activists say that. Tunisia is always an exception. And Tunisia seems to be a role model that many women movements are trying to push in that direction. So let's just talk about when it comes to male guardianship. Male guardianship is very important for a woman to marry, for a woman to work, for a woman to learn, for a woman to move. When it comes to Yemen, it's the male guardian is required for the marriage to be contracted. The guardian is respectively woman's father, son, brothers, sons, uncles of the father, their sons, etc. In Tunisia, marriage shall only be contracted with the consent of both future spouses. When it comes to divorce, before even we go to divorce, Yemeni family law does not set a minimum age of marriage. When it concerns Tunisia, it's 18. When it concerns divorce, the man has the right to unilaterally divorce his wife, 3 words. On the other hand, she has basically 3 possibilities. She proves with his consent, or if she proves harm, or if she gives up her financial rights. And when you look here, when it concerns Tunisia, divorce shall be carried out only before a court of law. And when it comes to obedience, it's the worst formulation that you find in the MENA region, and that is this article. 40. Wife owes her husband obedience, especially in the following 4 cases. He chooses the place of residence. We had that in Switzerland and ended in 1988. She fulfills his sexual desires. She follows his orders and undertakes her domestic chores, and she is not to leave her marital residence without his permission. And when you look at the Tunisian Code of Personal Status, it's a formulation that perhaps needs improvement, but at the same time, it's way, it's in a different direction than this article of 40 in the Yemeni family law. Each of the spouses shall be considerate, maintain good relations, and avoid causing injury to the other. And both spouses shall fulfill their conjugal duties in conformity with customs. What that means is open to interpretation, okay? And I hope when I say, when I showed the Yemeni family law, this is the classical jurisprudence, the one that is still stuck in this historical framework. And that shows the limits of Islamic law when we apply it in family laws. So given its historical context and the worldview behind it, classical Islamic law does not correspond to the 21st century's concept of universal human rights, where a human being enjoys equality and fundamental rights by the mere fact that he or she is born human. So I'm going back to the same question. What type of Islamic law is being used as a framework and implemented within British Sharia courts? The classical Islamic law with all its contradictions and discrimination. And I'm giving specific examples where what I did, because I realized when I looked at the research, the experience of women has been really well documented by several scholars. Samia Bano is one of them. So I thought maybe I should speak with the sheikhs themselves, see what kind of Islamic law they're applying. So minimum age of marriage, and that is in the Islamic tribunal. Sheikh Sadiqi, he is the head of the Muslim Arbitration Tribunal. In my view, puberty is the right age, but puberty is the minimum age. Then the next criteria is the decision of the guardian. He has to make the decision about marriage. When it concerns the guardian, I met this wonderful Imam, Sheikh. He comes originally from Syria. And I mean wonderful because the manner by which he was talking about how he is trying through his work to make sure that those who are coming for marriage are not forced into marriage. He's really working hard to stop this. But then you realize that despite everything, there is a certain framework that within which this work is being conducted. For example, a woman in her 30s wanted to marry. The guardian, he's younger than her brother, lives in another country. He called him to get his approval and to delegate his right of guardianship to another person, a male. She's in her 30s, living alone in London. So I asked him if her voice was not enough. And his answer was, the guardian is present. The guardian is present, meaning we have a guardian here and he will decide. And finally, and this is something that also very problematic. If you look at Islamic law jurisprudence and the Hanafi tradition, Islamic law has, when we talk about the Sunni tradition, you have 4 jurisprudence schools. One of them is Hanafi. The Hanafiya jurisprudence give a young woman who reached maturity age the right to contract her own marriage without her guardian permission. However, Abu Hanifa, that's the name of the jurist who created this jurisprudence, was very much aware of his context, so he connected this right with another right that he gave to the male guardian, and that is, in case the male guardian was not approving of that marriage of his own daughter or whatever, the ward, the female ward, he has the right to cancel, annul that marriage. Now, interestingly, it has been used, applied in the Islamic Sharia Council in Leeton and the Birmingham Islamic Sharia Council of the Central Mosque. And depending on the position of the judge, if he's trying to help the young woman or not, you will have a different position towards this kafa'a rule. In other words, they accept it as valid, but they will look for loopholes to support the young woman. And I can tell you a story later about that. But I just don't want to talk a lot. Now, if we talk about the type of the manner by which Sharia courts are applying the laws, Islamic laws, arbitrary. In other words, the treatment of the Sharia court, as I said, depends on the type of Sharia courts applying this law. It can either seek a fundamentalist interpretation, or it can make the lives of women easier by seeking the most lenient interpretation. And I saw that specifically in Birmingham, but that is within the framework of Sharia. The mindset framed by a perception, Sharia is God's law, no way you can change it, shaped by acceptance of the rules that regulate marriage, divorce, polygamy, guardianship, inheritance, anything related to family affairs and women's position within the family. Do not question them. And the judges reflected in the interviews that this is what Islam commands. This is what God commands, and we are following God's law. And with all due respect, jurisprudence, this is what men came with within a certain historical period. And they can change it. It can be changed. Treatment of women as minors, and this has to do with an attitude of a literalistic adherence to the strict, restrictive, parochial worldview of women, and insistence on their treatment as minors. And here I'm quoting someone that I really respect, Dr. Osama Hassan, who is also a sheikh, who is trying also very much to do a lot to help. And he described that treatment by mentioning, we're talking about a certain fundamentalist attitude. He said, the extremist clerics will say a woman can never marry on her own accord. She can never divorce on her own accord. She can never have equal inheritance with men, let alone more than men. And they are all basing this on a literalistic interpretation of the Quran, which is one of characteristic of fundamentalism in my understanding. And by the way, he is a very religious sheikh. It's not that he's coming from the outside, but he is providing a critique from within. There's a political dimension as well, and unfortunately, you see it more and more, and that is, there is a political dimension that we tend to ignore. Those Muslims in the West who call for the introduction of legal pluralism and the use of Islamic law are often affiliated with either forms of Islamism, societal or political. A societal is new fundamentalist movement. And when we talk within the UK, I'm talking about specifically about the Deobandi, for instance, movement. And when we talk about the political Islamism, Jama'at al-Islamiyya, because these are the one affiliated with South Asian Islamist movements. And the issue here is not only about conservative clerics and imams who are using the law in ways they have always known about. The issue is most significantly political. And the connection, it's not a claim, you can in fact show that through evidence. Members of the two types of Islamism, societal and political, often control British Sharia councils. Ideology, those who are working there display the ideological and political feature of Islamist ideology, a new fundamentalist reading of Islam. And co-optation, you have those specifically, or those working in the political stream of Islamism, they have co-opted the idea of weak legal pluralism to suit their own political agenda. So they frame the use of these Sharia councils as obligatory, religiously necessary, despite the fact they only existed in 1980. Before that, they were also Muslims. And presenting a decontextualized patriarchal interpretation of Islamic law as the standard that should be used. And most important, and here it comes basically to the social context, when it concerns the social context of women in close communities. I'm talking about specific strand within Muslim communities, British Muslim communities. Within the close communities, you have widespread gender-based violence, and that is basically has been also more and more shown. There are women with South Asian roots are more likely to live in poverty, to be unemployed, to be in poor health, and to inflict self-harm and attempt suicide, compared to their female counterparts of other ethnicities. And poverty and unemployment or economic inactivity compounded by the type of gender-based violence considered widespread within the communities. And here I'm just bringing some of the work of Muslim women movements, UK Muslim women movement, where they show that there is a big issue, problematic issue, rigidly defined matrimonial roles. Duty of women is to maintain the family izzat, honor, and bearers of community and family honor can bring shame or the shame on their families. And unfortunately, violence and physical abuse towards young women continue to be a community-sanctioned method of controlling their independence. Final remarks. why legal pluralism is not an answer to Muslim minorities' protection. Because I understand you have those who are really pushing for that because they think this will protect the minority rights. The main argument, we must look at the context of legal pluralism and its actual practice. We must also consider the consequences of introducing special laws. It is the consequences that should matter. And the consequences, if I look in the UK, in fact, it exacerbated the segregation that already exists, that I mentioned before. And you have two types of hierarchy. Within Muslim communities, one created a hierarchy where certain gatekeepers, religious leaders, elderly, were given power and control. And they are basically the one where the authorities, the British authorities, are communicating with. And you have they alone will be entitled to speak in the name of their communities and to decide on and define what they consider to be their community's interests and needs. And a second type of hierarchy within society in general, I mean, you have two categories of citizen, one that enjoys the freedoms and rights stipulated by the common law, and another that is deprived of them. So, last remark, the impact of legal pluralism, the one that I just basically described, is the legitimization of systematic discrimination against women and children, and segregated communities which have been polarized and we don't see as and we end up with lack of social cohesion. Thank you.
I really like your methodology in your book. What is the type of Sharia that is applied and what are the effects of Sharia? So let me share an anecdote of mine. I was once presenting my book on LGBT rights and free thinkers' rights in Egypt and Tunisia, and I received the criticism that I didn't stress well enough that stoning is not in the Quran. Well, besides the fact that it's not in Tunisia or in Egypt either, fortunately, I was just referring in general to the framework of the hudud penalties. And my answer was that for the person who received the stone, it's not that important that the stones come from the Quran, from Sahih Bukhari, from the Ijma'at, the Qiyas, because what matters is the fact that she's being stoned in the name of Sharia. So I really appreciate your methodology in this book. However, there is also a potential tension, I think, between one argument you make, namely that secularism, secular law, is the only framework for the protection of individual rights. And another argument that I think I have perceived in your book, namely the possibility of reformers changing Sharia. Actually, you accuse some academics or authorities to just accept what you call the anthropological version of the law, this fictitious Sharia, which is just some tribal reconstruction of a very archaic form of Sharia, instead of giving the floor to reformers. So what would you respond, for example, to the latest thesis from Abdullah Ahmed Anaim, who claims that Sharia can be a medium towards the implementation of human rights? Do you think this is a possibility that this reform effort could actually bring this possibility of having Sharia as a tool for the achievement of human rights, or you think that secularism is the only way?
Well, to be honest, I have great respect for Abdullah Naimi and his work. And any work, like my mentor, Nasr Hamid Abu Zaid, Professor Nasr Hamid Abu Zaid, the late Nasr Hamid Abu Zaid, he also was working on a way of finding a way out of this, how should I call, historical bubble that we're still living in, specifically when it comes to Islamic law and Sharia. And that said, I have to basically say perhaps the time has come that we, while trying to reform, because the issue of Islamic law is a matter of also addressing the mind and hearts of many people inside of the region, or people who actually believe that Islamic law is sacred, maybe it's time that we move away from a religious interpretation. Because on the one hand, I respect those who are saying you have many believers and they would like to have a framework that will enable them to practice their life according to their belief. On the other hand, I will insist that we are talking about religious laws that should be changed, ended in a manner that allows us to enter in the 21st century. As Naimi is trying to find a way of saying we can call it Sharia, but what he's actually saying is civil law. Like I mean, if you look in Tunisia, they provide a civil law, and they say it's based on Islamic interpretation, which is in a way true. But at the same time, it's a civil law.
Yeah.
But there are limits of how far you go with a religious argument. I mean, there are things, I didn't want to make an issue about showing Islamic law, how it's being practiced, specifically when it concerns women. It's just like, come on, guys, there's no way you can apply that today without telling me that this is infringing on her dignity and equal rights. So what I'm trying to say, I respect what he's trying to do. I will support it. But if we are going to be in argument in a parliament, I'll say I want civil law. But one based on these declaration of international human rights that respect the dignity and rights of an individual, regardless of gender.
Very clear, but let me play a bit the devil's advocate here. I had an interesting discussion with colleagues a few days ago about the balance of power in society. So you are now, with this, you are conducting a vigorous criticism of Islamic law, which is not actually the only religious law that you criticize in your book, because, for instance, you refer as well to canon law applied for Syrian Catholics or Syrian Greek Orthodox, and you show there is as well a violation of individual rights because of that religious law. But don't you think that, given the balance of power in our society, where Muslims are a minority, it is more problematic for their own rights to somehow criticize their religion, which is the religion of a minority, which can put them in a situation of further subordination? And let me rephrase this question through a metaphor that you use in your book. You refer to society as a game field, where each player has a different color, has a different individuality, but all play by the same rules. But the objection here would be, who made those rules?
Who made these rules?
So don't you fear that this formal equality you are advocating for can come at the expenses of substantive equality? What would you reply to this argument?
It's a very good in fact, argument. But I will start from where I started. I started from the Islamic laws that we are applying in the MENA region. And that critique was very clear in the first book that I wrote. Is that this has to be changed. This has to be changed. And coming to here, we're not talking about religious or faith. It's not faith I'm talking about. I'm talking about religious laws. Laws that tells you, if I am divorced by my husband 3 times and I want to go back to him, I have to marry another man, sleep with him, get divorced from him in order for me to get there, back to him. What kind of law is that? Religious laws that belong safely to this historical period. Think about the religious laws that were applied here in the 7th and 10th century, and tell me it's okay to apply it on women today? Why is it okay to apply it on Muslim women? This is all I'm saying. It's just, it's very often patriarchal structure, patriarchy, that men who would come and say, these are women, our identity. And of course, I see also some believing women who will basically defend the right of being subjected to these laws. But with all due respect, I am living in a state that is obliged to protect us and treat us equally. Not using any religious justification will end that, should end that.
So in a way, cultural relativism could become a form of racism, somehow.
And a tool for discrimination.
Yeah.
A tool for discrimination. So, why would I give up the law that respect my dignity and rights in Switzerland? And it was, I mean, come on, guys, look at the family law in Switzerland before 1988 and how it changed. Why would I give up that today to have the form that I sadly showed? The laws that I showed about Yemen, because that's the form of law that we're talking about. Yeah. It's not the Tunisian. If you want to apply the Tunisian, okay, call it whatever you want, but it's civil law. Yeah. But we're talking about this orthodox form of Islamic law.
And this reminds me of a quote of Bassan Tibi that says, is it legitimate that as a Muslim I can be tortured in the name of diversity? I mean, it can become the paradox of cultural relativism that wants to be lenient towards minorities and then somehow turns against those very minorities, or at least against some sectors of those.
And that's what I would basically urge those who are arguing for legal pluralism with a protection in their background of thinking, because I understand their urge for protection. God knows when I work within the region, my own region, and when it concerns minorities, I tend to have also similar kind of reflexes. I'm just asking, think about the consequences of what you're asking, and think about the type of laws. Look at the laws, and then tell me that it's okay to apply it.
Perfect. So let's open for questions. I remind that both people in the room as well as people following from Zoom can now ask questions. For those who want to intervene from home, please write in the chat and we will track your interventions as well. So are there questions in the audience? Yeah, I see already 3 hands. So Ruud, Dilek, Dario? Yeah.
No, it is on. I just have to talk into it. Yeah, thanks a lot, Elham. I want to follow up on your answer to Tommaso's question. So if you say, you know, it's maybe time to choose the secular option, what would it mean concretely? I see very clearly what it means in the MENA region or in the wider Muslim world. We're talking about family law like that also in Pakistan and Bangladesh. So it's not just the MENA region. Clearly, to abolish the legal status of these laws and to do away with these separate families. That seems clear to me. I think it's the implication for the UK case is also clear in relation to these Muslim arbitration courts or whatever they called, because they have an official status in British law, and their how do you call them, rulings are also legally binding. So there again, one would say, okay, that should be removed from UK law then. But what to do about the largely informal and not legally enshrined Sharia courts, where, you know, that have no legal status, and in which supposedly women and other minorities and vulnerable groups voluntarily agree to submit to the ruling of such a court. That would be a more difficult case, would you then be advocating to actually ban such Sharia courts? Because if you would not choose that consequence, then of course we would have to go the way suggested by Naim, namely then we should fight for a more liberal interpretation of Sharia in the hope that one can convince the imams and sheikhs ruling in these courts to eventually adopt a more liberal interpretation of Islam. So I saw you nodding, so I suppose your answer is we should do away with Sharia courts. Then the question is, of course, how to do that legally.
No, and what you're saying is very important because we have an issue. I wouldn't say that the women are voluntarily going there. They're going there.
I was being ironic.
Yeah, but they're going there because they have to. And that survey was very important, the one that was conducted by Channel 4, which shows that 61% of marriages that are conducted, Muslim marriages, are done religiously, not civil marriage. That is a big issue because many of them enter in these marriages thinking that these marriages are recognized under the law, and once they have this situation of divorce, they recognize, I don't have the protection of the common law, and I need to go to Sharia courts. So the question is basically, how do we end this mechanism first? I would basically say, yes, the book is arguing for an end of these Sharia courts, but first, start to talk. That survey was very important because the way it was conducted by many focal groups within closed communities, conducted by women, Muslim British women from within the communities. And through that, it was in fact an informal campaign to make women aware of the importance of registering the marriage. So from that perspective, I would basically say, make sure that the law of 1949, marriage law in Britain, is changed, just like the Christian, Quaker, and the Jewish communities. When they marry automatically. When they religiously marry, they are automatically registered. The law should change in order to include the Muslim communities, Hindu communities, because the British society has changed. And once you do that, you can, in fact, once you have the civil and common law applied, it will be easy to get a religious divorce, because I have to think about a woman who needs to live in close community. If she doesn't have a religious divorce, she will end up ostracized within her own society. So that means by providing these steps, you are enabling them to get an automatic religious divorce, because those who are not tainted by new fundamentalist interpretation of Islam will provide an automatic religious divorce based on civil divorce. But that's not what is being done there. But yes, the book is arguing for one law for all, but one law that in fact respect the international laws of human rights and gender equality, not any one law. I mean, you can have a secular law that is really infringing human rights.
Absolutely. Yeah. Dilek?
Thank you. Dilek Kurban is my name. This was fascinating. I learned so much from you. Thank you. Just one fun fact. Nikah in Turkish has the same meaning as in, it means civil marriage also. Interesting. Maybe it comes from the Ottoman, who knows.
Arabic.
Arabic, but I'm from, yeah. I mean, that interpretation maybe comes from the legacy. So a few quick questions I have. One, I was struck that the number of these Sharia councils is not known. How is that so? I mean, I understand these are very close communities. I can, understand the dynamics, but that in itself, I think, says something really disconcerting, that that means they're not under the radar of the state, really. I mean, certainly they're not regulated, but not to know even the numbers. I found that striking. A little bit maybe more information could you give about the difference between these Sharia councils and the arbitration tribunals, just in terms of jurisdiction, like who goes, like, you know, what is the separation there? Do people forum shop? Do they decide where to go? Or do they have sort of jurisdictional differences in terms of, I mean, subject matter jurisdiction? Or is it personal? You know, how do they differ? That wasn't, maybe I didn't understand. And then the last question I have is actually just following up your comments in response to the previous question. Since these are very closed communities, because the question is, you know, where can, just in terms of bottom up, where can, if there's any hope for change or, you know, liberation of these women, how can that happen? Because initially I was going to ask you whether there are any alliances or attempts by feminist movement, women's rights movements in the UK to reach out to these communities, but I guess the answer is no. I don't know whether they attempt, but I guess it's very difficult. But then the question is internally, because this survey you mentioned, that's of course significant, as you said. Did they, maybe we could see this as an attempt, some sort of small resistance within, right? But then you also mentioned in the Sharia councils, I think some imams who do adopt a relatively liberal interpretation. So are there any alliances or hopes for alliances there between, you know, these men in positions of power but who adopt a liberal interpretation and the women in these close communities, both who have done the surveys or who are aware of the problem, but also the others who are not? Thank you.
Thank you very much. Very important questions. Important is that, in fact, the UK had an inquiry about the Sharia courts, okay, and the councils. When you said under the radar, the numbers, yes, it's until today, and specifically also after the COVID closure, the situation from colleagues that I'm in contact with seems to be really went in a different direction, worse for women, I mean, in close communities. But there was the inquiry. I was invited to the House of Commons as an expert, as a witness, to give also results, as other women rights and women groups and activists within the communities. And 2017, suddenly you had a statement on the website stating that the inquiry has ended. The result, no results, but in the new elections, if one wanted to continue with the inquiry, one could basically use the outcome of this inquiry. In other words, it's too hot of a subject that the authorities decided to put on the side. That means they know, the state knows what is taking place. So it's not that they don't know, they know, but they cannot address it, address the problem. So that's one issue. You said the differences between Muslim arbitration tribunals and Sharia councils. The Sharia councils specifically addresses issues of divorces. It's really created for that direction. And 1982 is the first one that was created. And it's no coincidence that it was created by groups affiliated with Jama'ah Islamiyya, Muslim Brotherhood, Deobandi, and Salafi groups. In other words, you have a certain kind of a political agenda for this, but one has to be fair. It seems to be like they were trying to address as well an issue that was in the community. Muslim Arbitration Tribunal addresses issues related in addition to divorces, financial arbitration, and conflicts within communities, and makes it more of a parallel structure. What you said is very important when it concerns of alliances. Yes, that's why I cited Osama Hassan Sheikh Osama Hassan, Dr. Osama Hassan, because he is one of those men of knowledge, of religious knowledge, I'll put it this way, who are working with Muslim, UK Muslim activists, or those who are not identifying as Muslim, working together with different activists, groups, trying to find a way out. For instance, one suggestion was that you have in any religious marriage or contract that you automatically have the right to divorce yourself. This is a possibility within the jurisprudence of Islam, specifically the Shafi'i. There is a possibility that the husband delegate one divorce, one of his divorce, to his wife. And with that the wife will not be in need of his approval in order to get a divorce. You have those who are working together, trying to find a way, creating a form of Sharia council that provides for these divorces, religious divorces for the women without going through the ordeals that they have to go there, because some of these councils would demand that you have to give up your protected right to custody, financial rights, etc., etc. You have those who are trying to do that within the close community. And I have to say, the inquiry, the Sharia inquiry, has to do with the concerted efforts and work of British activists from within the Muslim communities. So it's not that they're sitting there and accepting it. They're trying very hard, but you have different very difficult structural dimension. A state that doesn't seem to take its responsibility to protect seriously, and religious leaders and conservative leaders who seem to be in control as well, and close communities.
So there was no parliamentary question, for instance, to have the results disclosed since 2017? There was no action at all?
And then you have Brexit. Notice what happened. You had that. You had some reaction from women organization. Brexit was very important to see. And then came COVID and the closure. And during these 2 years, the situation really, from what I'm hearing, is not exactly, it didn't get better. It went in the other direction. And it's this dimension that is, I've seen a situation that I've seen in Yemen, and that is in the heart of London.
Dario.
Yeah, thanks for the very clear but still understandable and deep conversation. I have a question regarding the role of basically tax policies, or let's say the incentive structure to register your marriage. Because, if you make a cross-country comparison, of course, you have Anglo-Saxon tax model is different than the German one. I don't know about the Swiss one. So do you think there is an important role, for example, that the German tax system, which is more conservative, basically provides an incentive to register your marriage for Muslim communities because it supports families? I don't know how much you know about the German tax system, but basically singles are overwhelmingly taxed.
Taxed?
Yeah, taxed, in terms of taxation. Okay. Whereas the Anglo-Saxon model, I think, has less redistribution from, let's say, individuals, from singles to families.
Yeah. Yes.
A short clarification question.
Please.
Because I was also wondering about this, not knowing how the British tax system works, but certainly in Germany that would be a disadvantage, unless, of course, you are not officially married, but you do have an officially registered partnership. So I wondered, these 60% who don't have a civil marriage, do they have a civil registered partnership or not even that?
No.
Okay.
No, that's the issue. Well, if we're talking about taxes in Switzerland, you are punished for being married. So my husband and I are punished for being married. Okay? So that's another issue. But when it concerns what we're talking about in the UK, for instance, there's also another dimension. A husband in a polygamous marriage, he's married to one woman, okay, registered in his that this is my family, but he's married to two other women. They receive benefits because they are considered single. There's an issue here. But at the same time, if we are talking specifically about laws, the Swiss law, which in fact was introduced in 1874, insists on the primate of civil marriage. First, you have to get civil marriage, and then you can marry religiously. And it was, in fact, done in order to confront a kind of, you have certain kind of Catholic churches' tendency at that time to make it difficult to marry across denominations, etc., etc. Minimum age of marriage at that time was 13, according to the Catholic Church. So hence came that law that said, no, first you have the civil marriage, and with that civil marriage you have a minimum age of marriage that is actually higher, and it is possible to marry across religions or denominations. It became very clear also to us in Switzerland how important that law was when a certain kind of scandal erupted, where it became known that in one mosque that is really respected, an outside imam came and conducted marriages, forced marriages, and it seems to be also child marriages. And this imam, and those who are following his lead do not ask for civil marriage first. And it is this part that we have to insist on: first civil marriage, and then. And that's not in the law in the UK. That's why women's rights organizations are demanding changes in the law in this respect. Marry civil, and then do whatever you want, according to whichever religion you want.
But let me ask you something. Let's go for a second to the matter of group rights, because you adopt a very classical liberal position that the rights of a group are the sum of the rights of each individual within that group. So do you deny outright the matter of group rights? Would you say that, to quote Tariq Moudud, a group can speak for itself at some level? And I'm asking this question not only on a philosophical perspective, but also from a very practical one. A state must find an interlocutor when it comes to managing diversity, integration, when it comes to managing religious agreements with a specific church creed, when it comes to making agreement to send imams into prisons, to deploy religious figures in schools. So Islam being a religion without a church, how would you, and it being impossible to have simply a plethora of agreements with individuals, how would you find representatives, trusted representatives? Which parameters should the government adopt to find representative groups?
I really appreciate your questions, because they really go to the core of the issues. It's not a straightforward answers that we can come with, and this is a very, very sensitive dimension you are talking about. But I have to say, I'm not really talking in just from a liberal perspective. In fact, it's the postmodern who seem to be going in a direction where they push for a very liberal perspective where anything goes. So if a group would like to regulate itself, then they have the right.
Classical liberal in your case. I want to remark that classical liberal.
Okay, yeah. But at the same time, what you're saying is very important as well. I just have a problem with a system that is very akin and similar to the millet system of the Ottoman Empire. That's what we are trying to introduce here. You are telling me basically each religious group will have its own family law, apply it on its own group. And that did not exactly lead to positive outcomes, and it has a very political ramification. And from a societal perspective, it leads its division. It doesn't lead to social cohesion. But how do you deal with religious groups? Muslim minorities. I prefer that when it comes, we were talking about religious laws. When it comes to religious laws, of course not. But when it comes to regulation of mosque, regulation of education, education of imams, these have to be done in a manner that makes sure that we don't end up with mainstreaming Islamist interpretation. So that means when it comes to curriculums, you have, just like that you have theology, Catholic theology in the universities, you have also Islamic theology, but really done in a manner to reflect this rich heritage, not to give me like a form of new fundamentalist interpretation and tell me this represents the Muslim. It represents a fringe group that became mainstream, unfortunately. So the curriculum has to be conducted and looked at carefully, really carefully, because as I know from my work on Islamism, and I looked at the curriculums used by certain Islamist groups, specifically Muslim Brotherhood, you see that it's the manner by which they use the religious texts that can lead to an indoctrination of children, dividing society, us and them. It's how you teach religion. You can turn it into a peace message or a message of hatred. These are difficult questions, and we have to address them with carefulness, differentiation, fairness, because I can see that you have those who would like to teach their children their religion. They have every right to do that. But at the same time, with the recognition that we do face challenges, and these challenges relates to specific new fundamentalist strands that seem to have the upper hand because they are more vocal than the others. The others, who are basically going on by their life, very much living their life, part of society.
Yeah, thank you.
You're welcome.
So we are slightly running. Yes, there is another question there. Also, for those on Zoom, speak now or be silent forever.
For the transmission, okay. Thank you for your wonderful plaidoyer for the equality of men and women. This is wonderful. I just have a specific question. I'm not a professional in this area, but allow myself to think nevertheless. Is this councils of Sharia a typical British phenomenon? Mm-hmm. Or is it in other European countries? Mm-hmm. Let's say, for me, what is a little bit shocking when I listened to your conference, you said Islamic law. Okay. Now let's say we would introduce today, we make Christian law. Everybody was protest. I mean, in Spain, until Francisco Franco died, there was only one divorcing law that was a Catholic church. It was only the church. So there was Christian law. And today, in modern Spain, divorce has a constitutional range. It's a constitutional right. Could you imagine that in the country of the laicism, France, a thing like this would be possible? Or would it be against l'ordre public and the political culture? Why is it in Britain? Thank you.
Yeah, sorry. Add something? Sorry. Actually, to answer your question, there was an informal case where thousands of Muslim men brought in their second and third and fourth wives into France, although it was against the constitution and the government, and also against the women's will, the first wife, so to speak. So, and this reminds me, because I wanted just to say something. You talked about multiculturalism that is based on group identity, which I agree with fully. And there's a book by Susan Okin. She wrote a book called "Is Multiculturalism Bad for Women?" Where she's talking about how group rights endanger women's rights, actually. So I think there's... just to add to his, but please do answer that.
Thank you.
Thank you very much for these two important input. British phenomena, of course, the Britain is also a very special case in that the relationship between the state and religion is not that clear. I mean, we've seen the inauguration, the coronation, and we've seen how the Church of England has a very special role in the UK system, and perhaps that's one of the reasons why even within the UK there is a hesitant kind of reaction from the side of the official Britain not to rock the boat for the Muslims because it can open the Pandora box regarding the role of the Church of England within Britain. So that's very important to understand. That said, I have to say, you can say this. Among new fundamentalist groups, you can be sure that this form of Islamic law will be implemented. Something else is that I said that my book was translated into German, and I added a chapter about the situation in German-speaking countries. And I have to say, we are still, this is a black, how should I say? Yeah, it's a blind spot. It's a blind spot. If I'm gonna to quote my colleague Matthias Rohr, it's a blind spot, and it needs to be researched. But what we can say is that with the second wave of refugees and immigrants of 2015, you have more and more people who are coming from countries that doesn't have experience with civil marriages. I mean, those from Turkey, those from the Balkan, they have this experience, civil marriage, civil law. But when it concerns this second wave, I will say there are some indication that some are opting for religious marriages only. And there is a study, I think, by Mahmoud, oh my God. It's in the book. There is a study conducted by a German scholar, Mahmoud Jabra. He wrote a study and did an extensive kind of field research, did interviews with more than 100 imams and sheikhs, and showed that there are tendency in that respect, and some actually calling for an emulation of the British experience. And perhaps that's why it's important that we talk about it today, in order to make sure that we address the challenges and the consequences.
So we have a question now on Zoom from Yasser Salimi, PhD candidate at the University of Warsaw. Do do you consider the revision of the Cairo Declaration in 2020 and the Council of Europe Parliamentary Assembly resolution considering Sharia incompatible with the European Convention on Human Rights positive?
That Sharia law is incompatible with Islam? Yeah, I consider it they're stating a fact. So it's not a positive or not, it is a fact. So I welcome it.
Yeah, perfect.
What does the revision of the Cairo Declaration you don't know.
I'm talking about the European.
Yeah. So if Yasser can clarify the revision of the Cairo Declaration in 2020, because I'm not familiar either.
Yes.
The revision of the Cairo Declaration. So in the meantime, maybe I saw that there was a question there, so we can...
Well, thank you first for this very interested debate. I do appreciate it, and I really understand pretty much about the impact of legal pluralism, especially when it comes to European context. From where I come from, I'm coming from Egypt. So you know that we have this kind of polarized society, because in family law in Egypt is mixed between Sharia, fiqh, and French civil code. And the it's contradictory, you know, it's work against each other all the time. So you have a very, very polarized society in Egypt when it comes to family law, you know, the patriarchy and so on. But what I want to discuss here, my question actually, because I've been working in a refugees immigration problem in Turkey. And during my work, I have conducted many interviews with specifically undocumented refugees in Turkey and specifically in Istanbul, among women. And actually, I was surprised that many of the women I conducted an interview with them about the illegal marriage as undocumented refugees in Turkey, they were wishing to have some kind of arbitrary council like this Islamic Council to solve their marriage problem, because I'm talking here about the undocumented refugees, which first, they don't know that even though if you are partially undocumented, you can register your marriage within the civil Turkish code, and this is because they are not working, they are not registered with the UNHCR, so they don't know their rights. The women don't know their rights, that even though if they don't have documented, they can go to the municipality and register it or ask for registration. So most of them, I would say the majority of them wasn't familiar with this kind of regulation. And second of all, the most undocumented women who come in, who are invited by their men, you know, they were in Syria, and the men come first in Turkey, and he have registration document, and he manipulated the women, you know, to go around the registration procedures and says, okay, let's go and marry with an imam, you know, in imam procedures, because this kind of procedures like us in municipality takes a long of time, and then we have to wait, you know. So in this way, they manipulated women, and women don't know about their rights, and they have to go to approve to go to imam. And you know, in Turkey, when you go to the imam, because it's prohibited to marriage in imam procedures, in Sharia procedures, when you go to imam, you have no right for divorce, you have no right for custody, you have no right at all, you know. And even though in other cases I have met in Turkey, within the political activists who are fled because of their activities, their political activities or social activities, and they are denied by the embassy in Turkey, the council and embassy in Turkey, Egyptian, Yemeni, Iraqi, and the number is counted, and they are denied to documentation So they don't have their document as a political activist. They don't have their document. They don't have their identification. So they cannot apply for a status, a refugee status, and they cannot apply for anything within the Turkish civil code, and therefore they cannot go for marriage. So either them, they go also for imam, and it ended in a very bad way that you don't have any rights or anything, and women are the loser at the end. So this takes me to my question that the interviews I made, that many of those women have wished if they had arbitrary counsel that can, take care of their marriage and to be registered marriage somehow, and they can go for divorce and so on, instead of facing the nowhere, the nowhere results.
I really appreciate the way you shared your experience here, because you really touched on a very important problem, and it exists in refugee camps. And the question for me is basically, how do we solve and address these issues? Should we address it by creating more problems, or should we address it by having persons, individuals, but also intervention, people like you, but interventions also coordinated by the UN to address these issues. But I'm not really sure if anybody is paying attention, unfortunately. I mean, when it comes to the refugees, and within with the rising numbers, you have different dimensions and problems that are being addressed, but this is like an issue that is not addressed. But I'm not really sure that having a Sharia court or council will be the right answer to this. I see certain measures taken. For instance, in Switzerland right now, there is a law that will be, I think it was introduced, that made sure that a woman, a refugee, a female refugee, will not lose her status. If she's coming because of her husband, she will not be left in nobody's land because of a divorce. Because very often you have those who are stuck in marriages and the husband is playing on her loss of her status as a refugee because of that. So you see certain kind of measures trying to address the gender dimensions that are very important. But what you shared, this has to be documented, really documented. I urge you to do that. And at the same time to suggest solutions, but not in a way, solutions that create more problems. Because if you have those who are going to apply Islamic law, it's not always exactly, you know my opinion, but that's my opinion. Maybe you will have a different position, and I would love to read it.
Yeah.
So
Thank you.
In the meantime, we had the clarification. Yes. Apparently, in 2020, the Cairo Declaration, namely the Cairo Declaration on Human Rights in Islam, was rewritten, and it now gives equality to men and women. And I don't know if you are acquainted with the evolution,
I would love
with the reform.
To read it. I would love to read it, because all the declarations, Islamic Declaration of Human Rights, unfortunately, were very often shaped by the clause according to Islamic law. You have this follow, but I would love to read it, and I appreciate that he mentioned it, just to make sure that maybe we see something, because there are changes that I see, for instance, in Morocco, about apostasy, where you have those religious scholars who came forward and they said, you can't kill a person because he or she would like to leave a religion. So this is fundamental. Such changes I welcome and I embrace wholeheartedly.
Yeah.
And I hope the Cairo Declaration will be the same, but I will check it today. That's just me.
Especially because
I'm going to check it today, tonight.
If I'm not mistaken, the problem there was what you mentioned in your book, namely speaking of equality in dignity, but not equality in rights, which is a usual trick that. But indeed, we welcome every positive evolution. Indeed, the case you were referring to in Morocco was paramount. Absolutely
paramount, and should be really commended.
We hope that this is the evolution that we are going to see more and more in the future.
Yes.
So thank.
Now? Oh, yeah. Do you really honestly believe that this can change through diplomatic talks, or can we expect more revolutions and revolts and uprisings?
In the MENA region?
Yes.
Yes. Do I expect more uprisings?
Yes.
That's a good question.
I mean, we saw the Arab Spring. I personally don't think it's over. I think this is an ongoing process, and we were just going to wait for another catalyst, another trigger to start off a new revolution or an ongoing. I mean, they lack the middle class, which could support them like they did during the French Revolution, maybe. But it seems to me also with the youth bulge and the growing young men there, that this is something we can expect before anything can be solved through talks and negotiations.
The youth bulge, for those who are listening, is basically a demographic feature of many MENA region states, where almost 2/3 of the population are under 30 years old. And if not addressed as an opportunity, that means providing them with work, with employment, with opportunities, it can turn into civil strife. It can turn to violence. Now, the problem is basically my recent research project is addressing the outcomes of the Arab uprisings, okay? And I basically state that we are talking about two different forms of states. Those like Yemen, Syria, Libya, they have a form of state formation that ultimately led to the civil wars that we are seeing. So I'm trying, using Yemen, to explain why we are having this civil war, why it wasn't surprising. I agree with you that the Arab uprising is ongoing. We tend to forget that 2018, 2019, you have the Sudan, you have the Lebanese, there's Iraq, I just wanted to say, yeah, and Iraq. So you have these ongoing uprisings. I'm just worried, to be honest, that when it comes to countries like Iraq, like Lebanon, like Sudan, we will end up also with civil wars. And it has to do with the features of the states themselves. I worry about Egypt. You also mentioned it's part of my heritage, Egypt. I worry also, but I'm not worried about a civil war. I'm worried about a hunger revolution. And there we might see something like the French Revolution. But it's ongoing, and the things that we are discussing in the region, 10 years ago we were not able to discuss. There are things are changing, moving forward on a social level, but at the same time, politically, the stagnation. You, of course, have these countries like the United Arab Emirates and Saudi Arabia that seem to be very much fascinated by the Chinese model, economic prosperity on the expense of political participation, you know. So it's an open question, and it's ongoing, just an ongoing.
Thank you very much. In the meantime, the discussion on the reform of the OIC charter is going on, so thank you for sending us your thesis, because this person made his thesis on this reform. So we are going to check it
I'm going to check it tonight.
So thank you, Elham. Thank you very much. And thank you to everybody who intervened.
Thank you. Thank you very much.